SJC-13641, Dean Tran versus Commonwealth.
Okay, Attorney Walsh, whenever you're ready.
Chief Justice Budd, members of the court, may it please the court, my name is Michael Walsh. I represent Dean Tran in this case. If it's all right with the court, I'd like to focus my argument on three specific heads. One is legislative immunity, one is legislative privilege, and the other is the issue with the grand juror. Mr. Tran is a former state senator who is charged with violating the state ethics law. He presently has a case.
Slow down a little bit.
Apologies, Your Honor.
Sorry, go ahead.
Mr. Tran is charged with violating the conflict of interest law in a pending indictment before the Suffolk Superior Court. He is charged for obtaining unwarranted privileges, and it is our first contention that this violates the general tenure of legislative immunity. Legislative immunity, Massachusetts has a more robust version of it than even the federal version, although for whatever reason federal congressmen behave worse than state legislators, and so the federal case law has advanced significantly in advance of our own. The seminal American case was written by this court in 1808 called Coffin versus Coffin, which I believe both sides cited in their brief. The general gist of the privilege is that because of the co-equal branches of government, the courts are not and cannot be, nor can the executive, be in a position to review the nature or decisions or acts of the legislature. It is essentially breathing room for the legislature to act. It is our primary contention that just the inherent nature of this particular charge, obtaining an unwarrantable privilege, places the court, the grand jury, and the trial jury in the position of having to judge the propriety of legislative acts. It is inseparable from...
But isn't that making the definition of legislative acts too broad? I mean, what they allege here is that he was using his position and his staff to advance his political reelection campaigns. It's not about this bill or that bill or should we do this or should we do that legislatively. This was a personal thing to, I want to be reelected. I want you guys here helping me do that. This is entirely divorced from the acts of a legislator in terms of the Commonwealth citizens, isn't it?
There are two related points to that, Your Honor. First of all is essentially the example of, you may remember Charles Sumner, the senator from Massachusetts, was beaten over the head by a representative from the South over slavery in 1856. And he was beaten in the well of the Senate over a speech that he gave. Clearly a violent act in the floor of the Senate, even if it's in the Senate, for example, would not be a legislative act. And that's what that distinction is allowed. But because of our constitutional provision, I believe it's in Part 2, under the House of Representatives, Articles 10 and 11, we, unlike the federal government, have a very specific charge that not only does it relate to legislative acts, but that the legislative house is the only judge of their own acts. They determine their privilege.
How does they passed 268A? And I mean, the legislature clearly created conflict of interest laws, right?
Your Honor, under the concept which is embedded in our constitutional case law of parliamentary supremacy, which we inherited from England, no session of the legislature can pass a law which binds the future constitutional privileges of their successors or their predecessors. So with respect to how the Commonwealth would like to interpret the conflict of interest law, if it even remotely falls... Essentially, Your Honor, the test isn't merely is the act legislative, it doesn't even smell like legislative.
All the statutes on political finance and conflict of interest laws are all unconstitutional if applied to the legislature?
Your Honor, I have never been able to, Your Honor may recall the case of Dinan versus Swig and Greenwood versus the Board of Registrars, which talked not about Articles 11, or not about Article 12, but about Article 10 in relation to the legislature's jurisdiction over their election clause. And I have never been able to square those two cases with the existing statutes.
Can I just go backwards to the point you were making that I just find troubling? So if I'm a state senator and I have a bunch of staffers that I know that are really great carpenters, and I say, hey, you guys are going to build me a new deck, and are you saying to me that because I get to say, hey, my staffers are going to build me a new deck, that I could somehow shoehorn that into legislative acts for purposes of getting immunity?
That is the absolute outer edge in where we stand to answer that question, Your Honor. I would, of course, answer yes, but primarily that dovetails into my second point, which is that even if this doesn't fall directly within legislative acts, that the Commonwealth can't use legislative evidence to obtain their indictment or to prove their case. This draws primarily from the Supreme Court in Brewster, Helstosky, and I've forgotten the third one, which says that legislative acts cannot be used as evidence anywhere. I know the Commonwealth had a section in its brief, and unfortunately, generally speaking, the best case that legislative acts can't be used as evidence even in front of a grand jury, as long as they're even remotely legislative acts, is the Ninth Circuit case that I cited in my brief, U.S. versus Renzi. So the short answer is, Your Honor, primarily, if you were to misbehave in that fashion and have your aide carpenters build you a house, under Coffin and several other cases, the House is the judge of that. They theoretically have the ability to fine, to imprison, or even to cut loose privilege and turn it over to the court. And they're just the proceedings here were just simply not formal enough to indicate an abandonment of legislative privilege by either the House withdrawing it punitively or by Mr. Tran waiving it. And so as a result, even if it's on the gray line of legislative privilege, because the privilege is absolute and because the House is the judge of its own privilege, the answer was to go to the House Ethics or the Senate Ethics Committee and get an opinion from them instead of bringing an indictment. Your Honor, one of the most important things in here, which I think was implicit in the briefs but not was explicitly stated, was that the Senate Ethics Committee and the Senate, when it referred the cases to OCPF, they looked at campaign finance violations. That's part of the reason that we offered the OCPF report as a factual basis in this case, but the Commonwealth or the grand jury elected not to proceed under those statutes. This was not referred directly to the Attorney General's office. This was referred to State Ethics Commission, which made a subpoena and then dropped its case. And then it was referred to OCPF, which had 3 specific charges they refer to the Attorney General, and then a completely different kind of case comes out of the grand jury. So even if you were to construe the referral by the Ethics Committee as some kind of withdrawal or waiver of the privilege, they didn't waive it for a conflict of interest issue, at least as to OCPF or the Attorney General. They waived it as to those very specific OCPF charges.
So you're saying, if I understand correctly, that that a legislative waiver can't simply be by enactment of a criminal statute that would cover the conduct at issue, but must be some legislative action passing or specifically waiving immunity with respect to a particular member of, in this case, the Senate, once it's brought to their attention? Is that your position?
That is the general gist, Your Honor.
So that means that there's a default legislative immunity for all violations of the criminal statutes for legislators?
Legislators are not super citizens, but we tolerate things from them that we would not tolerate from regular citizens because of the nature of their job. So as long as the acts in question are even remotely related to their job, specifically if they're related. We cited to Your Honor the in re sealed case from the District of Columbia and the D.C. Circuit. In that case, Representative Perry was engaging in informal fact-finding and relating to the January 6th certification in 2020, or 2021, excuse me. And the court there specifically held the line isn't political or not, it's not official or not, it is literally simply and absolutely legislative or not. So in terms of if a legislator murdered someone on the House or beat them over the head with a cane, as is in the case of Sumner, that is definitely not legislative, can't even pretend it, even if it occurs in the legislative House. But the disposition of legislative aides or communicating with, for example, from the Rayburn case, one of the things that we know is that a legislator communicating with his constituent, not in a public newsletter, but letter to letter back and forth, that is a legislative privilege.
So I just want to, I'm sorry to interrupt you. I'd like to go back to your Sumner example. The prosecuting authority would need to go to the legislature to receive a waiver before charging Sumner. Is that what you're saying?
The Sumner was the victim, Your Honor, but yes, essentially.
Oh, yes, sorry.
And that is what happened in that case, Your Honor. The House, the representative who beat Sumner, the local police authority obtained a waiver from the Federal House of Representatives, and he was subsequently prosecuted. He was only fined $300, but that's how that case turned out.
And the state legislators can rape their aides or kill their aides, and unless the legislature says that's okay, they
can't be prosecuted.
I think that's got to be wrong.
Well, Your Honor, the other famous historical example is John Quincy Adams' son, John Adams, was the private secretary of the president at the time. He was beaten by, in a physical fisticuff on the grounds on the Capitol while he was delivering papers between the House of Representatives and the president. And they said that even though neither combatant was a member of the House or an employee of the House, because it obstructed House business, the essence of conveying papers from the legislature to the executive, that was still within their privileges, and so they felt that they had the right to police it. In that particular case, they did not choose to do so, but it's not without remedy here. I'm running short of time, and I desperately wish to address the grand jury issue. In this particular case, Your Honor, as you're familiar, the grand juries have reputations of...
Didn't the prosecutor do what, didn't the prosecutor do what we want prosecutors to do when the grand jury said, hey, he's a trumper, and they basically said, you take a back seat? The prosecutor should have gone to the supervisory judge, but you're asking for dismissal with prejudice. How are you prejudiced by the prosecutor actually doing the right thing?
If I said with prejudice, Your Honor, at least as to the specific issue, I apologize. It should be a dismissal without prejudice.
Right.
But to answer your question directly on the nose, in separation of powers analysis, it does not matter if the power was used responsibly. It matters whether the power exists or not. The Suffolk Superior Court made a finding of good faith on my specific concession, and I have no reason to take that back, Your Honor. This was done out of the best of intentions. The problem is that if you say that this power exists at all, someone will later use it irresponsibly. Respectfully speaking, Your Honor, the prosecutor, for whatever reason, this is part of the reason that to the Superior Court we cited cases that grand jurors are not, that you are not exactly entitled to a bias-free grand jury. Grand jurors come into the room with all of their experience, their biases, and all that. The prosecutor, out of the best of intentions, attempted to screen for bias that she thought, but she made a fatal mistake in preserving the independence of the grand jury by not obtaining judicial sanction for the dismissal or at least exclusion from this particular case of the grand juror.
You say there's no finding of they don't have to find prejudice. You think it should be dismissal?
Your Honor, this is structural. So when we talk about the only things that justify pretrial dismissal on an indictment, we talk about the impairment of the grand jury. The only good case that we really have on that is McCarthy-Odell that requires the probable cause. But Your Honor, I ask you, if a prosecutor can come across a grand juror whose questions they don't like...
Even in Odell issues of integrity with the grand jury, there's an issue of prejudice, right?
There is an issue of prejudice.
So I'm not seeing where you get, other than pulling it out of the air, where are you getting structural error from this?
Your Honor, because this goes to the composition of the grand jury, which traditionally is regarded as a structural error. So with respect, at the very start of our republic, to get a grand jury indictment was a two-step process. First, the jury had to vote on what charges they wanted the lawyer to draft, and then once the draft came back, they had to approve the specific draft. That goes back to Commonwealth versus Smythe in 1853. Now, all of a sudden, the prosecutor is in the room, and now all of a sudden, the prosecutor is asking questions of the jury, and we have now reached a moment where the prosecutor can offer evidence or withdraw it from the grand jury's consideration, where the prosecutor can find grand jurors whose opinions they don't like and exclude them, or whose questions they don't like and exclude them, or even tell them, I want you to charge these crimes, not those crimes. And if that's true, no longer can we even pretend that the grand jury isn't a rubber stamp. Because the ability of the grand jury to say, I want to look at these campaign finance crimes or this gun broker evidence instead of the the conflict of interest law, that is their independence. Their independence is their ability to look at the prosecutor, thumb their nose at the prosecutor and say, I want to run away, I want to do something different.
So let me ask you a different question.
Yes, sir.
So if the grand jury, if you get the grand jury minutes back, and there was a grand juror that was completely favorable by either 1 degree or 2 degrees to your client, and then you got word that the indictment issued after the prosecutor in that case tried to exclude somebody who was very openly suggesting that your client was being unfairly targeted. You wouldn't be saying that you wouldn't be now saying that there's a problem here?
Under the argument I am now making, that would still be a problem, Your Honor. Now, whether a defendant...
Would you be making it?
I'd like to think I am avoided enough of a hypocrisy to believe so, Your Honor. More importantly, it's my job to scrutinize the process for any errors I can find and put the government at its burden in every conceivable way. My argument certainly runs against me in that context, and I like to think I have enough integrity that I'd push that opinion, Your Honor. But frankly speaking, I can't imagine a defendant sitting next to me who would want me to make that argument. For all that that's worth. Last, I know I'm running out of time, but with respect to the privileged evidence, we not only have the senator directing his aides, but we also have him directing his aides to coordinate his calendar, and that is a public function. We have him communicating with legislators, which under Rayburn, that is a legislative function. And so even if the indictment was properly drawn as to these particular charges, because it is based on legislatively privileged evidence, the indictment in this case cannot stand, and they should be dismissed without prejudice, as Justice Gaziano had me correct the record. Thank you very much, unless there's any questions from the court.
Okay, thank you. Attorney Johnston.
Good afternoon. May it please the court. Assistant Attorney General Tara Johnston on behalf of the Commonwealth, and sitting with me at council table is Assistant Attorney General Kristen Sullivan. To begin, the motion judge's decision affirming the motion judge's decision should be affirmed because, one, Mr. Tran has not presented a meritorious claim of legislative immunity, either on separation of powers doctrine or under the speech and debate clause. Two, the prosecutor's excusal of a grand juror who exhibited apparent bias against Mr. Tran does not warrant dismissal of the indictments, as the motion judge found. And three, to the extent that Mr. Tran still continues to raise the double jeopardy claim he raised in his motion to dismiss and his 211-3 petition, and it is not deemed waived, it too lacks merit, although he no longer does seem to be raising that claim here.
Can I ask just a fact question? So there wasn't a criminal prosecution by the Ethics Commission or OCPF, right? There's nothing. No,
Your Honor. There were civil sanctions imposed. Yes, there were civil sanctions imposed.
Nothing criminal.
Correct, Your Honor. Correct. As a preliminary matter, because I know it was asked in the reservation report, the Commonwealth does not contest that some form of interlocutory appeal is appropriate where a criminal defendant is claiming that a motion to dismiss was improperly denied on legislative immunity grounds. That is consistent with how this court has handled claims of double jeopardy and other claims not to be tried. And the Commonwealth posits that in Massachusetts, a petition to the single justice pursuant to 211-3 would be the appropriate avenue for seeking relief, because that is traditionally how those claims have been handled. And that is also consistent with the fact that the Supreme Court has held that there are 4 types of claims in criminal proceedings, although they have applied under the federal collateral order doctrine, but that claims of legislative immunity are entitled to some form of interlocutory appeal, like double jeopardy claims. Turning to the fact is, though, whatever this court decides in terms of whether or not it is entitled to interlocutory appeal and what is the appropriate avenue of relief to pursue, whether that be a petition to the single justice pursuant to 211-3 or the doctrine of present execution, which has traditionally been handled in Massachusetts just solely for civil proceedings. Regardless, it is no assistance to Mr. Tran, because here, neither his claim on separation of power under the separation of powers of doctrine nor the speech and debate clause have any merit. Turning first to the separation of powers doctrine, the legislature enacted 268A, the conflict of interest law, to address this exact type of situation where state employees are taking advantage of their position to secure unwarranted privileges or exemptions that are not available to similarly situated individuals. And under Section 26, they criminalized egregious violations of the statute that are committed with fraudulent intent. And in the statute, under Section 1, Mr. Tran falls squarely within the definition of state employee. The legislature clearly intended for this statute to apply to people like Mr. Tran.
So is that the waiver of the immunity, is the enactment of the statute?
The enactment, I don't think that there is a claim of legislative immunity for a violation here of there's no, for criminal statutes. So I don't think that Mr. Tran's claim that he gets some kind of legislative immunity from being prosecuted under criminal statutes is supported by any of the case law. In fact, I believe it is exactly contrary. If this court looks to the Supreme Court cases, and even Coffin v. Coffin, the 1808 Supreme Court case, SJC case he cites, but if this court looks to United States versus Brewster, if this court looks to Gravel versus United States, the court makes it very clear that the speech and debate clause or is not to act as a shield against criminal prosecution for legislators. That is not the purpose. The purpose is to protect legislators from being prosecuted or having to face civil suit from activities, communications that are essentially integral to the due functioning of legislative activity. So there's no reason why a state senator cannot be prosecuted under a criminal statute. And here, the criminal statute in place specifically puts people like Mr. Tran, state employees, within its scope.
But you're saying, I take it, that there's simply no room for legislative immunity when we're talking about a violation of a criminal statute.
I think that there is room for legislative immunity insofar as acts that are done in their legislative capacity that are integral to the due functioning of legislative activity would have to be put forward. So I would agree that there is a testimony and evidentiary privilege that would guard against that, but for the specific facts of this case, that is not needed. There is no reason why evidence of that needs to be put forth. Nothing of that nature was put forth before the grand jury, and there's no reason why at a trial on these charges, any legislative material of that nature would need to be put forward. Here, the conduct with which Mr. Tran is charged is quintessential campaign activity. It's door knocking to solicit votes. It's placing lawn signs. There is no case from any jurisdiction that the Commonwealth has found that has ever held that this is the type of conduct that is protected under either for separation of powers doctrine or specifically the speech and debate clause.
But I think his argument is not that the lawn sign placage is legislative activity, but that the communications with the staff are quintessentially legislative.
Right, and I understood, Your Honor, and yes, I agree. But the thing is that for the communications with the legislative aides to be protected, the communications have to be, the subject of them have to be matters that are integral to the due functioning of legislative activity. So if the communications were in regard to voting, drafting committee reports, enactment of legislation, absolutely, the Commonwealth does not contest that would be protected under the speech and debate clause. But that is not what we have here. We have it is strictly limited to testimony and evidence regarding campaign activities that had nothing to do with those functions. And Mr. Tran has not pointed to any specific examples. And if I ask this court, I encourage this court to comb the record to look through the grand jury transcripts, because it is very clear that no such evidence was put forward before the grand jury, nor would the divulsion of any such evidence or would any such evidence need to be elicited at a trial on these charges. Turning next to the question of the prosecutor's excusal of the grand juror. Here, as
The prosecutor should have gone to the supervisory judge, correct?
I would disagree, Your Honor. So, yes. So, well, there is no. It is not that they should have or they shouldn't have. I apologize. So I don't think it would have been wrong to, but I also don't think it was required. There is no rule. There is no statute demanding as much. And the law and the case law.
Whose grand jury is it?
Well, it is. I mean, it is the Commonwealth. It is the Commonwealth's grand jury, but it is. I don't. The prosecutor is.
It's under the supervision of the judge.
That was the answer.
Yes. So sorry. Yes, it is under the supervision of the judge. I apologize.
So then can you address your opposing counsel's argument that this is fundamentally structural error?
Well, so I don't think it is error, even if it is under the supervision of the judge. So yes, I agree. I'm sorry. It is under the supervision of the judge, but that doesn't change the fact that the case law states that the prosecutor acts as a minister of justice, essentially.
Of course, but why doesn't that just mean that when the prosecutor observes this and becomes concerned, the prosecutor is to go to the supervising judge and ask for the judge to take some action?
So certainly that is something the court that could be done, but there is no rule or statute demanding as much. Rule 5 that nothing states within Rule 5.
I think that's a backwards. It's like looking for the negative or something. I don't know what's exactly wrong with that in my view, but it's something like that. What authority, where would a prosecutor get the authority to excuse a member of the grand jury?
I think it's part of the fact that the Massachusetts appellate courts have recognized that prosecutors do have a duty to maintain the integrity of the grand jury proceedings. And I think there are practical issues with having to seek out a judge every time a grand juror needs to be excused.
But you can see the concern is,
yes.
In this case, that's great, that we can look at it and say, this prosecutor was trying to do the right thing by Mr. Tran. But you could see that, to your brother's argument, that it could be manipulated the other way, which is why there has to be some limiting principle to the prosecutor's ability to do what the prosecutor did here.
Well, absolutely, Your Honor. I could see there being taken advantage of, but I could also see what the prosecutor did here and it not being taken advantage of if every time that occurs where a juror is excused, there's a record made. And
Let's try it this way. Suppose we disagree with you,
yes, sir.
just hypothetically. Why isn't a dismissal, or why shouldn't it be dismissed?
It shouldn't be dismissed because even if this court finds that the prosecutor should have sought out the judge, or even if the court finds that going forward that is the appropriate way to go forward, there was no prejudice here. There was no prejudice here for several reasons, and I do want to point out that Commonwealth has only found 2 jurisdictions, California and New Jersey, that demand that it be that make clear that it cannot be a prosecutor who excuses a biased grand juror. And in California, it's the foreperson who is in charge of doing that. In California, looking into the guidance there, they review it for prejudice. And when you review it for prejudice here, you find that there clearly was no prejudice because the factors you look into are, first of all, the substance of the dismissal. Here, it was in order to benefit Mr. Tran or to make sure that the integrity of the grand jury proceedings were maintained, so there wasn't a biased juror sitting on the grand jury. 2, we can also look at the fact, and this is one of the other things that the California courts have looked to, is the fact that this was done out of the presence of the other grand jurors. It was not done in their presence when the prosecutor resumed questioning a couple of days later and excused this grand juror. And another factor we can look to is the fact that it took 12 grand jurors to indict this Mr. Tran. And so one less grand juror was one less potential vote for an indictment for Mr. Tran. Also, one of the things...
But I guess,
yes.
Why is... I have no issues with anything that you're saying. I guess I'm wondering why that's the right test. Excuse me.
Well, I think that is I think that.
Because
always
California does it?
Well, no. Usually, even in Massachusetts, where there's a question about whether the integrity of the grand jury proceedings, we look to whether or not that is prejudice. That is what is almost always done. And one of the things we're
So,
missing
given
here,
that it's almost always done, you must have some legal authority that you can tell me.
well, so I think one of the cases I cited in my brief before we looked to the, and I cited several in my brief of case.
And that's fine. If it's in your brief, I'll take it there.
It is. I think one of the cases was Woolham. We generally look to, though, the factors of whether or not there's prejudice when
there's information presented, false information to the grand jury, Odell, Mayfield, et cetera, right?
Yes, and there are other instances where there might be a claim of impairment to integrity of the grand jury proceedings. And again, in those circumstances, we do look to prejudice. But also, one of the things we're missing, and that is one of the reasons that the Commonwealth argued in its brief, is that this is not the appropriate juncture to be handling this, is because one of the things the court looks to for determining prejudice is also whether there was a guilty verdict of unreasonable, a guilty finding by a petite jury.
That's the federal rule.
But that is one of the,
Right, but you're citing the federal rule. Our rule under Odell is it leads to a motion to dismiss, and then there has to be a showing of prejudice, right? We don't wait till after the jury for an Odell motion.
No, but in other contexts of where there's claims of impairment in a grand jury proceeding, I do cite several in my brief, where it is you do look, one of the factors the court looks to is whether or not there is a guilty verdict by an impartial petite jury. Also, I just want to quickly address this idea that even if this court were to find error, that it would somehow be structural error. I don't think there is any support anywhere for that argument. And also, I think that I just want to point out structural error is very, very limited. This is a very narrow category of cases. The only situation where the United States Supreme Court has ever found structural error in the grand jury context is where there is racial or gender discrimination in the grand jury selection process, because it fundamentally affects the entire proceedings. And Massachusetts has followed suit to say this situation is comparable does not make sense, honestly. So I would encourage this court, if this court does think that it was error in any way and wants to address this claim at this point, wishes to address this claim at this point, that it look to the prejudice analysis, because it's clear that there was no prejudice whatsoever in this case.